Hello and welcome to this webinar today on creating value in trademarks and in your IP overall. As the slide shows, my name is Annie Blake. I'm an associate here at Burkitt Long and a chartered trademark attorney. We do usually have a question and answer facility online, but as we are recording today, we would invite you to ask any questions using the contact details that I will share at the end if you do have any questions about what's being discussed today. Throughout the recording, I will be asking the coordinators to move along to the next slide. So if we could go to the next slide, please. Thank you. I need to read this out to make you aware that the information is presented for general purposes only and does not constitute legal advice. This information is correct as at the 10th of October and is subject to legislative changes. And next slide, please. So here forms the agenda of today's webinar, and I will be discussing various topics under each of those headings. And the headings really form a checklist of how to tailor a strategy and how to implement robust and valid intellectual property in order to then gain value. We want to the webinar to show you that you can do things with your intellectual property. You can transact in them, you can license them, you can sell them, you can use them as a preventative tool to stop others from coming onto the market with a similar or identical brand to yours or indeed product. And so it's more of a whistle-stop tour around how to secure the most valid rights for your business and then how to use them to your financial gain. If we could go, actually, before we do, just to make you aware also that I will be using the acronym IP throughout the webinar. And as many of you will know, that stands for intellectual property. And intellectual property covers numerous rights, primarily trademarks, copyrights, patents, designs and domains. And whilst I will be happy to field questions on all of the different types of rights, and indeed the intellectual property team will be able to assist in any IP inquiry that you do have, today's talk will mainly be focused on trademarks as I'm a trademark attorney. All right then, next slide please, thank you. So understanding the benefit of registered rights. We can't very well talk about the benefit of registered rights or in fact how you can exploit these to your financial gain without first discussing whether it's worthwhile to have a registered right in place and what the advantages are of those. So with the first bullet point, unregistered rights does give you the clue that you can, in some cases, rely on unregistered rights depending on what type of IP we're talking about. But the difference is that although relying on unregistered rights comes with an initial cost saving, so it can seem a bit more attractive to a business who's busy doing other things or their resources and finances are elsewhere. The difficulty is that it's actually a lot less straightforward. So it might seem attractive at first to save that cost for the business. But when it comes to relying on your unregistered rights, it can often be very unstraightforward, doesn't come with with as many reassuring indications of a successful outcome, or maybe it's less easy to predict. But also there's always the requirement to prove goodwill when relying on unregistered rights, and that can be very onerous on a business in terms of the evidentiary burden that creates. Whereas with a registration in place, it can often be more straightforward, more cost effective in the long run, and can be quicker, it can tie up formal disputes more quickly, because the question of goodwill is more academic. So it can be more of a cost saving to have a registration in place. Now, the decision by a business not to register a design or a patent or a trademark can be quite damaging to the business, because there's always the question of if somebody gets in there first with a registration, that could potentially stunt your expansion plans. So to demonstrate that, I'm going to go on to the next slide, please, and explain through Burger King's story. Burger King during the 70s tried to enter Australia, and they found that there was already a registration in place for Burger King and already a restaurant in place for Burger King. And that meant that they were blocked from using and registering what was their worldwide brand, and it caused them to think what they could do to go forward in this market of interest to them. So they opted for a new name in Australia only, and to this date they still operate under Hungry Jack's and not Burger King, which we all know and love, maybe depending on how you're feeling on the day. So Hungry Jack's, it did work out. There was a positive spin on this story, and that is that after 40 years of using the brand name Hungry Jack's, there was the opportunity for the owners of Hungry Jack's to commence use of Burger King in Australia, but they decided against that because after 40 years of using one particular brand name, despite it not being consistent with the rest of their branding, they had built up brand recognition and goodwill in Hungry Jack's, and they remained as that. However, the reason I bring this to your attention is not to explain that there's a positive spin at the end, because that's not always the case. It's really to prompt the question to you: what would you do if in a market of interest to you, somebody had got there first? If there was prior use or prior registration, what would that mean for you? If it's so important to enter a market, then it's really a lesson to sort of show you that it's the sooner you think about registering, the better, and the sooner you start thinking about which territories you want to register in, the better. So if we could go back, please, to the slide, thank you. So that's unregistered rights and sort of some of the impacts to business that it could have. In terms of registered rights, they, as I said earlier, they are more straightforward often, and they are more cost effective in the long run, although there is initial prosecution costs to begin with. But also they are more attractive to stakeholders if you are heading into investment rounds and you've got investors or stakeholders who are often reassured that you've got the right protection in place to be able to protect and to defend if needed in a more straightforward way. It shows that you take your intellectual property seriously and act seriously as a business, and it creates more of an investment opportunity. And the fact that you can transact in intellectual property because it's an intangible asset, but it can be used for financial gain, is also attractive to stakeholders and investors. So also, finally, on that point, actually, it acts as a gateway to achieve registered protection in other territories where if you have a home registration, for instance, a UK registration or an EU registration, trademarks that I'm speaking about right now, it enables you to file internationally more straightforwardly. So now that I've piqued your interest into the benefits of having a registration in place, you might wonder what can be registered. And there's, as I discussed at the very beginning, there are a number of registered rights that can be achieved, and some might surprise you. So I'm just going to go through a short list. So designs can be registered, and designs protect the appearance of a product, not the functionality. So if we go to the next slide, please. So a pattern can be registered as a design, and this is a design extract from the pattern registered by Louis Vuitton Maletier, and this is one of the patterns that is applied to their bags, one of many patterns that they have registered. And a pattern can be something that you would apply to a tea towel if you are a tea towel manufacturer, or to bags like with this example. Next slide, please. Or you might be able to register your packaging as a design. So here, this is Coca-Cola's UK design registration, which protects their bottle, and they have many registrations in place protecting their packaging. And as the pictures show, there are various angles which the images are presented in the application form, and we can assist with that as to what type of angles you will need, what type of pictures, to show and give context to what you're seeking protection for, to perhaps disclaim what you're not seeking protection for. And next slide, please. And then you could have design registration for elements of a shoe. So this is a Brazilian design from Nike International Limited, or held in the name of Nike International Limited. And where a design registration is quite helpful is where, in circumstances where you can't, where it's more difficult to prosecute your trademark application through to registration, because the examination criteria for a trademark is far more stringent and stricter, whereas there isn't really an examination process as such for a design. But it doesn't necessarily mean that the design will be valid to rely on at a later point. We can assist also in advising as to that aspect. So if we could go back to the slide, please. There is also patent protection, and that protects a new or a novel invention, so such as the functioning of a product or a manufacturing process, and it often provides a technical solution to a problem. So you have the monopoly right in exchange for making the invention public. And then there's copyright, and copyright cannot be registered in the UK. It is an automatic right, provided that it meets particular criteria. And it can be registered in some jurisdictions, such as in the US. What we say in the UK, and what we recommend, is particular ways of protecting your copyright by keeping good records. And I go on to that at the very last slide when I discuss using your IP, to give you some tips to keep that protection in place as robust as you can. And then there is trademark protection. And with trademarks, there are a number of different types of trademarks. And as I said at the beginning of this slide, I think some may surprise you as to what can be a trademark. So if we go to the next slide, please, I'm going to show you what can be a trademark through the eyes of Christian Louboutin. So here are a number of trademark registrations from the UK, downloaded from the UK Intellectual Property Office register, the trademark register. And as you can see, there's a number of different types. You've got in the top left and right hand corners logo marks, and then you have a word mark in the top middle, and word marks are actually very, they provide the broadest protection. They're very helpful to a business which might change its branding over time, change the colours, change the positioning, and a word mark allows you to make changes to it, provided you don't change the actual words themselves or the order or anything that would provide any sort of overall significant difference. But you can make changes to the font, the appearance, and the size and the positioning. So it can work out as a sort of a good investment to file for a word mark, and that allows you flexibility over time with any rebrands you may do. And then on the bottom row of this slide, you'll see a number of shoes type marks. These are actually position marks, and what this aims to protect is the exact colour red, that's the left and the middle, the exact colour red, and that's a Pantone shade that's specified on the register for that exact area of the shoe. And that provides Christian Louboutin owners to enforce and defend, relying on the exclusive right for that particular area. So that's very helpful. And there is also sound marks that you can have registered. So the MGM lion, when you start watching a film, that MGM lion roaring is also a trademark as well. Although I won't demonstrate that today, but I do look like that and sound like that most mornings. So going back to the slide, please. Thank you. Oh, it's the next slide. Apologies. If you hold it there. So just wanted to make one final point on the last slide, that there are various different strengths of trademark protection. Whatever you come up with and whatever you want to go forward with will have some sort of positives and some negatives in terms of the protection it will result in, and we can assist in advising you on that. So the next slide, identifying your IP needs and assets. It's really important to point out that this particular slide, and indeed the whole webinar, is not focused solely on new businesses who you might sort of associate with needing to identify their IP because they're just starting out, they're aware of what they've got in place, and at the starting point is when you tend to assess how you will drive forward. Now, this webinar and this slide is focused also on well-established businesses where branding can maybe become stagnant or overlooked, and a fresh approach or a fresh look into it is advisable, because over time your branding will change the way it speaks to your consumers. So this slide is mainly about stock taking, what you've got, where there are gaps, and what you need to do about it. IP is everywhere, the first bullet point. The reason I've put this is because it's not just talking about your registrations and what registrations you need, but there are lots of different IP needs that the business should look into to check that they are firmly protected and ring-fenced in all of their protection. And for instance, in IP clauses in your employment contracts, we can review any contract and draft any contract. And when with regards to the IP clauses in your employment contracts, have you had a look at those to see that they're robust enough to your requirements? Is there any mention of any confidentiality requirement? Perhaps you have trade secrets, or we can draft non-disclosure agreements if those trade secrets are required to be kept under lock and key, and you need assistance with that. Perhaps you should take a look and review any contracts between third-party service providers, such as graphic designers, for instance, who may have assisted you in preparing your logo for your website, for instance, or for your leaflets and your publications. How confident are you that the correct assignment has taken place, if indeed any assignment of those rights has taken place? So something that we recommend that you review or send to us to review, and we will be happy to do that. And even down to the copyright notice on your website. Is it appropriate? Is it legally appropriate? Is it held in the correct entity? So all things that you should be considering along with registering. So the second bullet point is really important, that knowing what IP you have will assist you with your strategy and your precision in planning that. And so planning a strategy is really about, well, I will come on to that in the next slide actually, but planning a strategy can be assisted by and started by a portfolio review, and that's a service that we can provide here. And what a portfolio review does is well, we will produce a report for you in which we provide recommendations as to what we see that you're not using to the best of your advantage in terms of your intellectual property, and what you could do to negate any risks or drive down the level of risks or make your protection more robust. And to do that, we consider what goods and services you offer. We review your website and how your brand, your intellectual property is being displayed, and what your markets of interest are, what your goals are. So it's very worthwhile to do. And once you have that report, you're then able to move forward with more certainty as to where your budget needs to be focused, and you could come up with a staggered plan, perhaps, if budget is an issue, or if expansion is dictating particular markets at particular times. Okay, if we could go on to the next slide, please. Thank you. Formulating a strategy for your IP. So as the slide shows there's no one size fits all strategy. So hopefully once you've had a portfolio review, or you've done some level of consideration of what you've got and where there are gaps, you need to have a bespoke strategy for you, which we can assist with. So that could mean that your intellectual property considerations are very different from the next business. You might have different commercial sensitivities and budgets and expansion plans. A bricks and mortar store which primarily trades out of its store and has a website but doesn't really rely on that so much, will not have the same considerations as an online retailer whose e-commerce site is the lifeline of their business, and hence they are likely to register all of the domains around their domain name, all of the similar ones, as a sort of defensive mechanism, a defensive strategy. So every consideration will be different for each business, and we recommend having a chat with us about what might be helpful for you. Something that's not on the slides that I point out is that you should be considering what type of trademarks you're going forward with and the various strengths, and that's something that we can assist with too, because each, as I said, comes with various strengths and weaknesses, and so some are more recommendable than others. For instance, a sound mark is more difficult to register than a logo mark, for instance. But we also within that point we advise that you consider the practical elements of any new trademark or brand that you're considering, because if you have special characters within your mark, for instance, such as M&Ms, my favorite chocolate, then they have practical implications when it comes to social media. So you will likely want to be buying up all of the social media space around your new brand. And something to bear in mind is on Instagram, for example, M&Ms cannot use the hashtag M&M because the ampersand breaks up their hashtag. So they have to go by hashtag MANDM, and that gives a really different look and feel to their business. It might not speak to their consumers as they would like, and it might not mean that their brand is as accessible as they would like. So things to bear in mind. And letting go of deadwood, really means, is the business expensing any time and cost on registrations or IP rights that it really that don't benefit the business anymore, and is it time to let them go? All things to consider. And then to ensure you've got the best armory and to avoid disputes, it's really good to have an action plan in place for conflict. So that could mean creating an internal policy for how you would deal with infringement in particular territories by third parties before it happens. And the reason that would be good for you to have those chats now is because often when involved in formal dispute, you are facing time critical situations where quick decisions have to be made, and those decisions might not be of the greatest benefit to the business. So if we could go to the next slide, please. Monitoring the brand activity of your competition. So you as a business or as another business that you know of may have started their launch, maybe in pre-launch, and they could be in a situation where they have bought in all of their stock and they come onto the market only to find that they are sharing a similar or identical brand to another, and they are sharing the same market space, which is going to cause conflict, and one of the parties isn't happy with that. And so often a business, without running the necessary due diligence or being aware of sufficiently aware of competitor brands, run themselves into a situation where they have tons of stock which could have cost tens or even hundreds of thousands that they are unable to shift, and facing defending costly and lengthy litigation against them. So we always recommend, firstly, being aware of what IP your competitor owns, and that is twofold really. That's to avoid unwittingly infringing on them, but also to see what they're up to show you where you could innovate next. So it's a win-win to be more vigilant. And in terms of taking the necessary due diligence, before proceeding with a trademark registration, for instance, we would always recommend, and indeed we provide, comprehensive searches. Now, these aim to firstly identify whether your trademark or your other intellectual property right is indeed available to register, because or if someone else has got it, are there any options available to you to approach them or seek consent or cancel their trademark? And also not just to see whether your mark is available, but also to see whether there are any earlier risks that are going to pose a problem to your use and registration, whether they are likely to prevent your use and registration, and what can be done about it if there are any options available. It's a service, a payable service, but there once again is a cost saving in spending that initial budget now to be in a position of making changes and modifications at this point, rather than going later down the line and finding out there's an issue where you can't make the changes, and that will be ultimately at greater cost to the business. Also, watching services is another service that we provide, and this is an invaluable service which I cannot herald enough. It is good for a number of things, and it enables you to act quickly. So a watching service scans the registers of all of the different countries of interest to you where trademarks are published, and we produce a report to you showing you all of these, and this puts you in a quick position to be able to oppose these applications that are of concern to you. It enables you to recognise infringement going on. It enables you to, well, it provides a prompt, because if you oppose a particular application and the applicant decides as a form of counterattack to try and challenge your mark on the basis that you haven't made use of it in some territories, then you could face having your registration cancelled either in part or in whole. And so seeing what applications are around, whether there are any similar or identical in markets of interest to you where you already have a registration, will act as a prompt to enable you to start making use once again, depending on the time slots that can be discussed with us where appropriate, if you have that situation arising. And then finally, if you have what's called a priority application, which I can explain at a later point if this is necessary when you contact us with your inquiry, a priority application will enable you to file in any other country of interest that is signed up to the Paris Convention, which governs the priority applications. You can backdate your rights to the earlier filing date of the first filing, thereby starting your rights in that country sooner than when you did in fact file. And so that can be really helpful where you see an application filed in a country of interest to you, and you hadn't necessarily got around to filing your priority application because of budget consideration, budget constraints, etc. You then are prompted that you need to do something right now. You can then file on the basis of priority, and then your rights are earlier than the application that you have an issue with, giving you a greater basis to take action. So it's really helpful to have a watching service for a number of reasons. If we could go to the next slide, please. Thank you. Okay, tackling copycat use. So you've got your rights in place, and we really recommend that you do make use of them in the appropriate way by enforcing and defending your rights, because they are an investment to you, and you may as well exploit your investment to suit your business and to protect your business. So it's definitely worthwhile thinking about enforcing, but where there are a number of issues that crop up, we do often recommend, rather than a whack-a-mole approach where you are trying to deal with every single issue, which can be prohibitively expensive to your business, we do recommend being more selective. And that really, in order to be selective, it's a cost versus benefit analysis as to what disputes are worth picking out and what disputes are worth leaving. And to assist you in making those decisions, you might want to think about who is using the similar IP. So is it a very small trader? Is it an individual where there might be adverse PR consequences if you took up issue with them? And how are they used? Oh, excuse me, sorry, I did forget to say one thing there. So it might be an individual, but it might be a very large, well-known company with very deep pockets, and then you could be potentially facing very lengthy and costly litigation. And is that worth it to you? You need to weigh these things up, or is there an area on which you could negotiate where settlement could be achieved instead? And then we move on to the next part of that. How are they using it? So Something else to consider in your weighing up of whether it's worth taking action again in this particular issue that you come across is whether it's parody use and that's detrimental to your branding, or perhaps it's counterfeit, or perhaps it's very seasonal use and it was your trademark was used or something similar as part of a promotion for 2 weeks, and by the time they've taken it down, you're just starting to assert your rights. And so in that instance, it may take longer to assert and enforce your rights than the actual length of the infringement which occurred. That's not to say it's not worth looking into any damages at a later point, but it's all these considerations to be made. And then set aside additional budget. Whilst you don't know what's going to crop up, brands knock shoulders sometimes, and brands can enter a similar market space on a number of occasions throughout the lifeline of your business. And so we recommend setting aside additional budget to be able to deal with your disputes as you would like, rather than what budget dictates at the time and what budget is available, where you may not be able to achieve every single thing that you would like to do if you don't have the necessary budget in place. So and the next bullet point is about being diligent, and that can mean reporting instances of infringement straight away, educating your staff. The watching service is good for being diligent and being able to report instances of infringement straight away. Also, you might want to record your intellectual property with customs, for instance, your trademarks, because customs then will act as a barrier where it's another party looking out for your business and looking out for whether there are potential infringements, and then they'll contact you if they seize something and give you a level of control as to what happens with those goods that have been seized. So that's a very useful tool to being diligent and enforcing your rights and defending and protecting your position. And finally, you might decide that you need to have a look through your own contracts and agreements. Being diligent doesn't just mean what might impact you, but also what you might impact. So are you aware of all of the undertakings that you've signed and all of the agreements and all of the terms that mean that you stay protected and you're acting within your contractual obligations? Okay, if we could go to the next slide, please. Thank you. Okay, so we come to the last slide, and this is all about making use of your IP in the correct way. And if you do make use of your IP in the correct way, and therefore it's valid, at that point, that's when it's good to look at how to make your IP work for you, how it can give you financial gain, because it is an asset that you can do things with to the benefit of your business. So use it or lose it. I mentioned briefly during this webinar that if you don't make use of your trademark, it is vulnerable to cancellation, either in part or in whole. And so we recommend, and that's not just in the UK, that's in a number of territories. So we recommend making use or recommencing use if you are aware of this point now, and there is a territory where you're not making adequate use, just to maintain your protection. The second bullet point, using the mark as filed. Now, a number of businesses, most businesses, may be guilty of registering a logo, for instance, and then over time, as their branding changes, as their visions change, and they might not be using the trademark exactly as it was filed. They might have dropped some elements of it or repositioned it, changed it round. And it's really important to know that if you're not using your trademark as exactly as it was filed, you're not protected from a registered basis. You are building up unregistered rights in that, but as was discussed, it can be often more costly to enforce such rights. So it's a good idea to take stock of what you do have registered and to make sure that you're still using those trademarks exactly as they're registered. And we can obviously assist with identifying whether that's the case, or assisting with any new trademark filings that you might have. And so coming on to the crux of the webinar, now that you've got your intellectual property properly in place, you've got the right IP working for you, and you've got the best protection you can in making sure that the use requirements are met, then it's time to look at how you can get the most from your IP. Now, first of all, I come on to licensing, and licensing allows you to, there's a number of situations, it allows you to either make use of your mark and allow another party at the same time to make use of your mark, and thereby acting as a second stream of income to you. Or you might decide that you're winding down on your use, you have less interest in the mark, or less interest in continuing to, excuse me, I do need to have a drink because I'm getting really croaky. Excuse me. You might decide that you are winding down your use, and therefore you can license your trademark to a third party, or your IP to a third party who will make use of your intellectual property, where the goodwill and the reputation and the profits will accrue to you. So essentially you can sit back, relax, and allow all of the profits to come your way, or all of the goodwill to come your way on your terms. So a contract is drawn up, a license agreement, and you it can be very pro you in terms of what terms you want specified in the agreement. There are a number of different types of licenses to have. So you could have, for instance, a non-exclusive license, which is where a number of parties make use of your mark, and this is often at a cheaper cost, at a lower price, but where the profit lies in the volume of users. Or you might, for a significantly higher price, excuse me, for a significantly higher price, you might decide to license to an exclusive user, and therefore just having the one user at more cost. So licenses can be very useful, and they are also a good leverage for if you don't necessarily have the resource or time or the interest to pursue an opposition, or you are slightly on the back foot. You might decide to license your IP as a form of negotiation, where a similar brand might benefit from using your IP more so than you have the energy for at the moment. So it's a good thing to take stock of and see whether that could work for you. I apologise. The next way of making the most of your IP and realising that it is an asset is that it can be transacted, it can be sold, and the price of selling your IP can vary on a number of factors. So it might be that you have, well, whichever party has the greatest leverage in the circumstances tend to dictate the price. There might have been adverse or very positive PR associated to the IP recently, and that may have a sway on the costs. Or how desperate you are to sell it. If there's a deal, a separate deal going on, and you need to get rid of it quickly. So selling is also another worthwhile thing to look into, particularly if you're losing interest or your focus is shifting elsewhere. Then it's a good idea to get some money for it rather than let it go. And then collaboration is also a really recommendable option for exploiting your IP. And collaboration is where you might not be targeting a particular consumer that you would like to, and another party successfully targets that consumer. If you come together to create a new product or a new brand, this can often create public excitement around both of your brands, and it gives both parties kudos. So to demonstrate that, I'm going to ask to go to the next slide, please. And this is a website extract taken from Primark, and it shows Greggs, the baker, and Primark, the cost-efficient retailer, the clothing retailer, coming together to form a number of items that create this air of excitement around both brands. And what it does, it creates almost a buying panic, a buying excitement, because shoppers flock to the shops to get their hands on these products, because they could very well be limited edition, depending on how long the collaboration is in place, and it injects an air of excitement, certainly, to the brands. And this might be something that you've not thought of before. That certainly two entirely different industries can come together, and people love it when businesses are getting on. So it's always a very happy story. There's quite a lot of collaborations going on at the moment. I think Netflix, I seem to recall reading about Netflix and Ben & Jerry's, and they have a number of very interesting ice cream flavors as well. So it's something to bear in mind to make your IP work for you. If we could go back to the slide, please. Thank you. So educating your staff. This is really important in terms of maintaining your protection. So this really means that have you thought about disseminating your brand guidelines to your staff, having internal talks on how to spot counterfeit, and reporting infringement, and most importantly, because this is a concern particularly of my own when I see it happening in action, and I need to remind my own clients, and I'm making a recommendation to you that historically you may have entered into an agreement with another party which has particular obligations, such as not to use your trademark in a particular manner or in a particular locality, and the directors of each business go through various correspondence, and they get the agreements executed, and then the agreement sits in a drawer somewhere, or sits with the lawyers who assisted with the who coordinated the agreements. And who's to say that staff operating within those respective businesses have been made aware of these terms? So how confident are you that your staff know of any obligations that have been signed by a director? Could their negligence in this regard, could their ignorance in this regard, sorry, could that render a breach of contract scenario? And how would that affect the business? Because that would likely impact on your protection and and anything that's required of you to make sure that your IP is working for you, if your staff are undermining that perhaps without their knowledge. So we really do recommend educating your staff on any agreements entered into, and not just keeping it at top level. So finally, housekeeping and the importance of maintaining good records. Well, it really is important. So by that, I mean keeping documents always dated. For instance, anything that you create, it's really good practice to have all of your documents dated in case your dates of first use are ever questioned. Keep documents pertaining to ownership of your IP in case your ownership is ever challenged. And this is important for copyright as well, to make sure that you have good records, and perhaps and also keep documents of your trademark in use. So any news articles or any celebrity endorsements or any or packaging is really handy to keep centrally, because although we as your lawyers will have records of your deadlines, and we will be contacting you to talk about maintenance at various stages of your IP term of life, you tend to hold as the client the key documents such as the registration certificates or the evidence of use. So to keep that in order, we recommend appointing an IP champion or an IP super user, and they can be responsible across your business for collating all of this evidence at various points, so that it's accessible and central and ready to be accessed at the required time. It can be so time consuming and of great inconvenience to a business where evidence is needed, perhaps for instance a renewal of a US trademark where evidence is required in order to keep it maintained and to keep it registered, or perhaps during an opposition or a cancellation action you will be required to adduce evidence. And so I've had in the past a company whose whose staff that were responsible for furnishing such evidence were in Indonesia or in China, and they were so far dispersed that it became problematic and very slow communication wise to get hold of these people and to make sure that they got their evidence and then the right evidence. So it saves a lot of back and forth correspondence, and we really do recommend that. So there you have it, a whistle-stop tour of all the aspects that are required to think about making sure that your IP is working for you. And then once that's in place, what your IP can do for you to achieve financial gain and to achieve benefit. So we can assist in anything that I've discussed today, and we can help you create these items. We can help you license them and sell them. And we'll be very happy to field questions on all sorts of intellectual property rights. So it's been a pleasure to speak through this with you, and I look forward to hearing from you. We'll go to the next slide, please. Thank you. So we have a survey that we would be very grateful if you would kindly answer. It's a short feedback survey, and if you could complete that, that's mainly so that we can improve our future webinars. We'd be very grateful. If we go to the next slide, please. Thank you. So as I said at the start, this is a series of a number of Wednesday webinars, and our next webinar is on the an employment law update. That's on the 19th of October. And if you are interested in our future webinars, please visit our website at burkittlong.co.uk/events or our Eventbrite page in order to sign up. Thank you very much. I'm Annie Blake, and there's my contact details on screen, so don't hesitate to contact me if you have any intellectual property inquiries. I'll be very glad to assist.